All right, so my favorite, what to do as a lawyer is to give a disclaimer. This is not legal advice. The big picture here that I really wanted to convey is that the Secure Act is pretty long, pretty exhaustive. We just tried to cherry pick out the provisions that we thought were most applicable to this group. But by no means does this even cover or touch on all of the changes. You can see that from the numbering alone that we've just picked a few of the things that we thought are most applicable to this group. So this is not a complete presentation of the Secure Act. And it's very brief, it's topical. We traditionally don't draft retirement or qualified plans, but as someone with employees, I think this will be relevant to you because it'll either affect you as an employee or someone that participates in a qualified plan, or will certainly affect your employees and how they participate with the plan and their eligibility. Okay, sorry, a little lag there. All right, so here's the actual citation, public law number 116-94. The citations that we include throughout the presentation are actually citations to the Act itself, not as they might be codified in the Internal Revenue Code. So just note that difference. This was interesting because this was passed at the end of 2019 as an attachment to a spending bill. Basically, every couple months it seems like we hear that the government's going to shut down unless they pass a new spending bill, and then all of a sudden Congress acts at the last minute and the appropriations are passed and you have the funds to pay for it. So it's just interesting that this was kind of passed last minute. Sorry, I have a little difficulty sometimes going between the slides. All right, so the Secure Act, this is interesting on the timing. Kind of a funny story. I was sitting at the Loyola Estate Planning Seminar at the end of 2019, and this must have been the fifth or sixth topic of the day where the presenter was going to present on the Secure Act. We were basically told at the beginning of the presentation, you don't have to listen to this because there's no chance that this will pass. We hear it's dead on arrival. It's not going anywhere. Well, as my luck has it, of course it did pass, and of course I get to speak on it. And I did tune out the presenter as soon as they told me I had permission to tune out. I wish I could go back in time and actually listen and pay more attention now. But this passed early through House and Ways means in April, and then it was ratified almost unanimously in the House of Representatives in May. Then it sat and did nothing until basically the government was going to shut down. So then it passed the Senate 71-23 right in the middle of December. It was signed by the president the very next day, and then it had an effective date of 11 days after passage. This kind of threw the estate planning world up in arms because it really didn't give a lot of time to plan. And what we can see here is the first bullet point is really going to be my presentation. The second bullet point we'll reserve for John Rochelle, and he will talk about, and this is what I was alluding to, the second bullet point really is the effect of the plan kind of eliminated a widely used method of estate planning, which is involved in the stretch IRA, quote unquote. But the first part are the provisions that expand and simplify access to the retirement plans. And the overall goal of this was to encourage more people to participate in qualified plans, to encourage savings, encourage activity that would promote retirement. Well, when you do that, it comes at a cost. So if you encourage people to participate in plans, they're effectively deferring the payment of taxes. And if you defer the payment of taxes, the government receipts are less. So the second bullet point, which limits the stretch IRA, is designed to be a revenue raiser, to make the bill more revenue neutral. The estimates that I saw, it's about a $16 billion swing once you add up the costs and the savings. Okay, so the first group of items that we'll talk about are retirement plan distributions, the changes under the Secure Act that affect retirement plan distributions. Section 108, I wasn't even aware that this was an option, but apparently some plans had a feature where you could actually attach a credit card to your retirement plan. And if you use the credit card, it would act as if you made a loan to yourself from your retirement savings. Obviously, this promotes use of spending your money on things other than retirement. And the change here is designed primarily to say that if you use a credit card and the credit card is attached to the plan, it is not treated as a loan under any circumstance. It's treated as a distribution. And if it's treated as a distribution, then you would be subject to the early withdrawal penalty. So this discourages people for using funds other than retirement. Moving down to the next bullet point, section 109, which is the portability of certain plan assets. We understood that it was reported that something like 9% of qualified plans held annuities within them. And this section would encourage the use of annuities within plans by allowing plan participants to roll over annuities from one plan to the next without incurring a surrender fee or any charges on rolling that over. So this promotes the use of annuities within plans, essentially. The next bullet point, section 113, I think you'll see this, this type of distribution made with respect to younger couples. So previously, if you took money out of the plan before your age 59 and a half, then not only do you get to pay the taxes on that distribution, you also get to pay that 10% early withdrawal penalty. Well, what this change was, if you have a child or if you adopt a child, you can take $5,000 out of your plan and it is not subject to the 10% early withdrawal penalty. If you are married, then each person can each take $5,000 out of their plan and use it and not be subject to that penalty. So that's a nice use of proceeds and to get them out of retirement and to use them at a time probably when you do actually need the money. All right, so section 114, this is the last slide on distributions. We are changing the age when you have to start taking money out of a plan. So the simple concept is you put the money in the plan, it grows tax deferred. Congress doesn't want you just leaving the money in forever and just allowing that deferral to take place indefinitely. So the arbitrary age that I think had been set since the 60s or so was at age 70 and a half. They've extended that age from 70 and a half and moved it back a year and a half to age 72. The net effect is that no one is going to take that beginning distribution in 2021. It depends on when your birthday is and how they calculated when you turn 70 and a half. And there's another rule there for a spouse. If your spouse is the beneficiary of the plan, they might be able to defer when the plan participant would have turned 72. But that's a pretty big change because it's been 70 and a half for a long time and now it's 72. I understand that that is partially to take into account that people are just living longer, working longer. So they're moving that age back. All right, section 106. We're going to shift on and discuss a little bit on plan eligibility and contributions. So this is who is eligible to participate in a plan and how can you make contributions to the plan. Section 106, I have to say, was a little bit humorous for me because you really don't encounter this scenario. Under an IRA rule, you can only contribute up to the IRA to the extent that you have taxable income. So if you don't have taxable income, you can't contribute to the IRA. apparently there was a group of college kids that were receiving educational fellowships or stipends, and that is now treated as compensation. And because it's treated as compensation, they can just take the value of those stipends that they don't apparently need for their own living and use them to contribute to the IRA. So I'm assuming that people that will make use of these provisions, their families probably have other funds that they're using to pay for college, but it just opens the door to a small class of people to now participate in the IRA. Section 107, this is the maximum age for traditional IRA contributions. So if you participate in a 401k or a Roth IRA, there is not a limitation on how old you can be and still make plan contributions. Previously, there was a limitation that said if you're older than age 70 and a half, that you can no longer make contributions to a traditional IRA. You were aged out. It didn't matter if you were still earning income. So they have repealed that rule to allow people, regardless of age, to make contributions to a traditional IRA. And I think that will benefit a lot of people that are working longer, that choose not to retire and still want to participate, and that may retire later but still want to contribute towards their retirement savings. The last note under Section 107 is previously there was a way to escape if you were going to receive a distribution from an IRA. You can make a gift to a charity directly and avoid having to realize those funds as income first. Because they've changed the rule of who can contribute to the IRA, they basically say that if you make a contribution, then your ability to take a deduction is lowered by that amount. So it's really a rule to just match up that change in law to the other law that allowed for a qualified charitable distribution. All right, Section 112. I think this might be significant for some groups of employers. Previously, the people that were allowed to participate in a plan, in a 401k plan, were usually just full-time employees. Here, what Congress is allowing is that certain part-time or long-time serving employees may now be eligible to participate in your 401k. And the rules are based on hours, so more than 500 hours, but less than 1,000 annual hours. This group of individuals may now be allowed to participate in your plan. So that is going to broaden the class of who can participate in the plan. Section 205, these are qualified plan non-discrimination rules. Really, these pertain to defined benefit plans. Most of the plans we see are defined contribution plans. So the participant says, I'm going to give X amount of dollars into the plan, and your deductions based on what you actually contribute. The defined benefit plan just defines with certainty what you'll receive on the back end. In practice, if they didn't make this rule and the defined benefit plan was closed and did not allow any new people to participate, then over time, this plan would just not be eligible. What it does is it modifies the rules and says that existing participants, if they stay in the workforce and stay in the plan, it will allow them to continue to participate and for the plan to remain eligible. All right, so moving ahead, switching gears and discussing some of the Secure Act provisions that relate to the plan setup, the plan administration, and the plan funding. Section 101, multiple employer plans. This is another provision that I think could affect groups of companies. Previously, there was a quote unquote common interest standard. That has been repealed. And now what it does is it allows employers and unrelated businesses to create a single plan for plan years after 2020. And this will give an opportunity for small employers to group together and to basically have a more efficient and less expensive plan. So on their own, perhaps they chose not to have a plan, but together the economies of scale might allow them to have a multiple employer plan. So this could be an opportunity for groups of smaller businesses. Section 102. This is discusses qualified automatic contribution arrangements. So what Congress understands is that if you don't give your employees the ability to take money out and you mandate that they contribute, they will save more. So if you take that off the table and you mandate or impose automatic contributions that apply unless the employee opts out, they are more likely to just leave it set that way. And they're going to increase the cap on what you can set as your automatic contribution rate from 10% to 15% of the employee compensation. And that starts this year in 2020. Section 103, Safe Harbor 401k status. This overall just encourages the adoption of plans by providing safe harbors. And basically, if you adopt the safe harbor plan, then you should feel confident that it's going to qualify. All right, moving ahead, section 104. This discusses small employer pension plan startup costs. So this slide and the next slide are both credits, and they can work together. So this one applies so that an employer will be incentivized to start a plan because it essentially defrays the qualified plan startup costs. The maximum amount that you can receive is going to be $5,000, but it will depend on the number of non-highly compensated employees that are eligible to participate will ultimately determine the full amount of the credit. The next slide, section 105, this is another credit, and this is for small employer automatic enrollment. Again, we note here that if you auto-enroll, it will increase employee participation, it will increase retirement savings rates, and the tax credit is $500 per year to employers to defray the startup costs for new 401k plans or simple IRA plans that include the automatic enrollment feature. And again, this is in addition to the plan startup credit allowed. It's available for 3 years, and the credit will be available to employers that convert an existing plan to the automatic enrollment design. All right, section 201. This is similar. So conceptually, plan adoption after year end. So we're all kind of familiar with the fact that you might be able to contribute to your plan before the due date of your tax return. So if you have a 401k or if you have an IRA, you can make a contribution basically, through April 15th of the next year, but have it applied towards the prior year, which is good because you haven't figured out what your taxable income is going to be and how much you might want to contribute. So it allows you time to do that math and make your contribution. It's a similar concept here as to where basically the employer can adopt a plan after year end, but it's treated as if they had been adopted as of the last day of the taxable year. And the additional time to establish the plan provides some flexibility for the employers that might want to consider the plan, and it will also give some time to the employees to receive the contributions for that earlier year and begin to accumulate retirement savings. So it creates a fiction which is designed to essentially promote employers to adopt plans. Section 202. This is the planned combined annual reports for group plans. So this can be a headache to file basically the tax return for your plan, the Form 5500. I believe there's some pretty steep penalties if you fail to file this return. What this does is allows for combined annual reports of plans. So there are some rules on who can combine. It has to be the same trustee, the same fiduciary, the same administrator. But if those facts apply, then they can file the consolidated form 5500. I just wanted to note at the bottom bullet, this is effective for returns and reports filed in plan years beginning in 2022. So this doesn't have the same effective date as other provisions of the Secure Act. I think I might have skipped the slide. There we go, section 203. Disclosure regarding lifetime income. So I think the theory here is that if you provide better information, it might change behaviors. I think this will also require them to provide information on annuity payments as well. So this is designed to provide additional information. It requires the disclosure of the benefit statements on every year. You have to give it, and it has to illustrate the monthly payments that the participant is going to receive if they participate in an annuity or a joint surviving annuity. So better information here. Section 204, Leon alluded to this, is that if you have a fiduciary duty, if you were the administrator of a plan, and the overall idea here is to provide a safe harbor if you pick a lifetime income provider. So these are the insurers for the guaranteed retirement income contract, but if you follow the rules, then you're protected essentially against a claim for a breach of fiduciary duty if you follow the safe harbor. All right, just two more slides from me, and then we'll let John take over. These are, I couldn't figure out how to group these two items, so I just put them as their own slides. I think these will affect a lot of people though. Section 529 plans, we're all familiar with these. Originally, they were for post-secondary education. The definition of what is a qualified higher education expense is being expanded, and now it includes the expenses of registered apprenticeships. So before it was 2 year, 4 years, now we have apprenticeships. And then student loan repayments are also qualify as an expense. So you can make a qualified distribution to pay the principal and interest on a qualifying loan under the Secure Act using your 529 plan proceeds. So this could possibly apply to someone. I just wanted to note that it's also for the sibling of the designated beneficiary. That can also be treated as a qualifying distribution. The kiddie tax, this was adjusted. Previously in 2018, the Tax Cut and Jobs Act included a provision that said if you have, if you're a child and you have unearned income, that they're going to use the trust and estates tax rates. And trust and estate rates are going to have a higher marginal tax that comes into play at a lower amount of income. So under the trust and estates tax rates, you're going to pay more tax. I think Congress realized that this inadvertently pulled in a group of kids. Some of them are the Gold Star children that are receiving unearned income from payments for, because their parents are deceased military personnel. Now all of a sudden, the income that these Gold Star children were receiving were being taxed at the highest marginal rates under the trust and estate rates. So the Secure Act repealed parts of the prior law and says, now we're going to go back to the kiddie tax where you pay it at your parents' rate, not necessarily the trust and estates rate. So that was a big change. So we can transition. Proud of myself, I'm 3 minutes ahead of my allotted time, to John. I'll turn it over to John Rochelle, and John's going to talk about, I gave the provisions on how people were going to save money. John's going to tell us how Congress paid for it.
Thanks, Matt. My name's John Ruchel. This is the first time I've had the pleasure of addressing the ACC. Hopefully it's not my last. I took note that my two law partners' first comments were about the length of their hair, and as you can see, that wasn't a problem for me, getting my hair cut in COVID. My topic is going to center on the concept of a stretch IRA. But before I get into it, I've got to say, I don't know who Congress goes to get these anagrams for their acts. You know, the Secure Act, the actual wording is setting every community up for retirement enhancement. There's nothing secure about this act, and furthermore, there's nothing about retirement enhancement here. What's going on in my section of this presentation is actually a reduction in the benefit of using qualified retirement plan benefits and IRA benefits, if anything. One of the things that we need to keep in mind is the changes dealing with the stretching out of the retirement plan required minimum distributions involves new Internal Revenue Code section 401A9 capital H. It's interesting how the drafters put this together, because what they are doing is the new provision layers over the existing provisions a great deal. So in order to understand the new provisions, you really have to understand the old provisions and how the new provisions change. Some of the old provisions and important parts of the old provisions are still here. But so let's talk about the rules for 30 years prior to the effective date of January 1, 2020 on stretching out the retirement plan benefit. Under the old regime, you really have two layers of analysis. And in analyzing the requirements under the old regime, the fork in the road was the definition of designated beneficiary. The term designated beneficiary was and continues to be a term of art and a defined term in the Internal Revenue Code and Treasury regulations. And its definition is basically a warm body, a live human being is a designated beneficiary. Therefore, your estate is not a designated beneficiary. Your succession is not a designated beneficiary. A charity is not a designated beneficiary. And very importantly, most, but not all, trusts are not designated beneficiaries. There are two important exceptions to the trust rule, and we'll get into that in greater detail later. But under the old regime, and now also under the new regime, by the way, you first look to see, do you have a designated beneficiary? If you do not have a designated beneficiary, either because the IRA designation form or the 401k designation form names a charity or names a not qualifying see-through trust, or names the estate, or unfortunately, the client doesn't have a beneficiary designation form or can't find it, so that by operation of law, the estate becomes the beneficiary, it would not be a designated beneficiary. So if you don't have a designated beneficiary, the second fork in the road is if the client has died on or before their required beginning date for required minimum distributions, formerly 70.5, now 72. If they die prior to that time and there's no designated beneficiary, then the plan benefits must be paid out in annual installments over 5 years. If, on the other hand, the client has died on or after the required beginning date, then, and there's no designated beneficiary, then the plan benefits must be taken out in annual installments, but can be stretched out over the remaining life expectancy of the deceased client. Conversely, if the plan has a designated beneficiary under the old regime, then the benefits can be paid out, the required minimum distributions can be paid out over the life expectancy of the designated beneficiary. And furthermore, if that designated beneficiary dies before their life expectancy calculated at the time of the benefits begin, then the next in line successor beneficiary steps into their shoes, and the period of time over which the required minimum distributions can be taken out, their life expectancy gets added together. So you can see that under the prior regime, it would be possible to name a younger child, or maybe even a grandchild, as a successor beneficiary. The standard advice we would give our clients under the old regime, probably still good advice under the new regime, is if husband and wife are living, what you should do, assuming the marriage is stable and assuming both the husband and wife have no health problems or mental problems or whatever, where they would need a trust, for example, to take care of them instead of in their own right, name the surviving spouse as the beneficiary. The marital deduction would apply for federal estate tax purposes. For income tax purposes, the surviving spouse could roll over a lump sum distribution into their inherited IRA or their own designated IRA. They then name a child as the beneficiary or a grandchild as the beneficiary. And you could see under the old regime, if you named a grandchild, for example, they might have a 50, 60, 70-year life expectancy over which you can stretch out and thereby dilute those required minimum distributions. Why would you want to do that? Well, you would want to do it because while the benefits are within the plan, they are growing income tax free. They go in on a tax deductible basis, they grow income tax free. The longer you do this, the less you are taking out of the plan for your retirement, and the more you're sheltering income. So the government, for that reason, doesn't want you to treat your retirement plan as a tax shelter, but really something to facilitate your retirement. So that's why they created the required minimum distribution in the first place. And there was a perception that the stretching out was happening so much that more often than not, people were actually treating their retirement plans as tax shelters. So in comes the Secure Act. Under the Secure Act, instead of a two-step analysis, it really takes 3 layers now. Once again, under the Secure Act, the first thing you must do, the first step, is to determine, do we have a designated beneficiary in the first place, just as under the prior law. And if we don't have a designated beneficiary, the same rules as under the prior law apply. So once again, if we don't have a designated beneficiary under the Secure Act, if our client has died before achieving their required beginning date, now 72 instead of 70.5, as Matt pointed out, then the benefits must be taken out annually in annual installments over 5 years. If, on the other hand, our client has died after achieving the required beginning date and age, then the benefits can be taken out over a period of time equal to our client's remaining life expectancy at the time of their death. So that's step one. Step two is important because this analysis, if you satisfy step two, then the period of time you must take it out increases from 5 years to 10 years. And in step two, if you have a designated beneficiary now, the period of time it's over 10 years. So the benefits must be taken from the plan if you have a designated beneficiary under the Secure Act by the calendar year in which the 10th anniversary of our client's death occurs. Now, the important thing here is if you satisfy step two under the Secure Act, and in fact you have a designated beneficiary, you don't have to take it out in installments. You could literally, on December 31 of the 10th year, take the entire thing and not having taken out any in the interim. You can take it out in installments, but you can take it out all at one time in the very, very end of the 10-year cycle, thereby leaving the benefits in the plan to grow income tax-free for that period of time. There is a third step of analysis that you should go through under the Secure Act, and that is there are 5 classifications of designated beneficiary that will permit you, instead of the 10-year rule, to use the actuarial life expectancy of the client in stretching out your IRA. The 5 categories are the surviving spouse is a so-called eligible designated beneficiary. The second category is a minor child of the client. The third category is a disabled beneficiary. The fourth category is a chronically ill beneficiary. And the fifth category is a beneficiary that is less than 10 years younger than your client. In most of these instances, you are allowed, if you satisfy all 3 of the tests, you can use the actuarial life expectancy of the eligible designated beneficiary. And then when that beneficiary, eligible designated beneficiary, dies, whether it's the spouse, the minor child, etc., then the 10-year rule tacks on at the back end. So you would then have the life expectancy plus an additional 10 years over which to stretch the required minimum distributions. I'll get into a little more detail in each of the 5 categories in a minute. But I'd like to turn right now in a little bit greater detail about to talk a little bit about the 2 exceptions to the rule that a trust as a beneficiary is not a, quote, designated beneficiary. There are 2 exceptions. One is for a so-called conduit trust, and the second exception is for a so-called see-through accumulation trust. What is a conduit trust? Basically, a conduit trust is a trust instrument. It can be either an inter vivos trust or a testamentary trust, whose provisions say and direct that the trustee has a duty to withdraw the required minimum distributions each year. And then, as soon as practicable, virtually immediately, the trustee is then directed in the trust instrument to take the required minimum distribution and in turn pay it right over to the beneficiary of the trust. If you satisfy those 2 basic requirements, then the code and the regulations for the so-called conduit trust basically ignores the trust and treats the beneficiary receiving that required minimum distribution as if that beneficiary was the sole beneficiary of the trust. The second exception is the so-called see-through accumulation trust. A see-through accumulation trust, again, by its terms, requires the trustee to take out the required minimum distributions from the plan. But unlike the conduit trust, the trustee is permitted to accumulate the income and pay it over to some other beneficiary. It could be in the future, whether it's, say, the first beneficiary or maybe a principal beneficiary, another beneficiary down the road. To qualify as a see-through trust and therefore to qualify as a designated beneficiary, each and every beneficiary of that trust must themselves be designated beneficiaries, meaning they must be warm bodies, individuals. You can't have a charitable beneficiary. You can't have another trust which is not itself a see-through trust as a beneficiary. You can't have an estate as a possible contingent beneficiary. So those two are the important exceptions to the general rule that trusts are not designated beneficiaries. Therefore, they can't be eligible designated beneficiaries. Therefore, you're going to be subject to the old 5-year payout rule in most instances. Let's talk about each of the 5 categories of eligible designated beneficiaries in a little bit greater detail. First, the surviving spouse. In many instances, the traditional advice that I alluded to earlier that we would give to our spouses as clients who are both alive and who are both well and who, there's no problems in the marriage, go ahead and name each other as the full beneficiary. That's still good advice under the Secure Act. The provisions of the Secure Act do not change the rules for spousal rollovers. The marital deduction protects you against estate tax. The rollover is still permitted. The surviving spouse under the Secure Act can name a beneficiary and everything's fine. But here's the thing, here's the difference. Under the Secure Act, when the surviving spouse dies, the secondary beneficiary named takes the benefits, but at that point, the 10-year rule kicks in. So unlike the prior law, even if the spouse died before her life expectancy, you could not pull in the life expectancy of the next beneficiary to stretch out. So now, if the surviving spouse is the direct beneficiary, you get to use her life expectancy, but then at her death, the 10-year additional rule tacks on. What if the surviving spouse is not a person that can handle the money well for themselves? Maybe, early onset Alzheimer's, dementia, something like that. So it's important that the benefits not be given to him or her directly, but instead you feel the need for a trust to protect those assets. Well, since the benefit is going to go to a trust, we have to look to one of those 2 exceptions to the general rule that a trust is not a designated beneficiary. So we look to a conduit trust. Well, a conduit trust, by definition, the trustee has to take that required minimum distribution and pay it out directly to the spouse. That may not fit with the client's needs. So we may not be able to go to the conduit trust. Well, what if we go to the see-through accumulation trust where the trustee can accumulate the income? The problem here is that with the accumulation see-through trust, there are deemed to be other beneficiaries of the trust, And as a result, it does not qualify as a see-through trust because it has other beneficiaries. It may also not qualify for the federal state tax marital deduction. Will not qualify because of the trustee's ability to accumulate income. To get a QTIP, or qualified terminable interest property, elective marital deduction, the trustee must distribute all income at least annually. So we've got a dilemma here. We may not be able to satisfy all of the client's needs here. If the surviving spouse is disabled and needs a trustee, we may not be able to stretch out beyond the surviving spouse's life expectancy through the uses of trusts. Let's talk a little bit now about the minor child, the second eligible designated beneficiary. Note, the statute and the regulations say that this minor child must be a child born of our client. Stepchildren do not count. Grandchildren do not count. Step-grandchildren do not count. So beware. There are many, many second marriages with children, yours, mine, and ours. Only the children born or adopted of that client qualify for this, and the child only qualifies during the period of minority. Once the child hits the age of majority, then the 10-year rule attaches, just like with the surviving spouse. So if you have a minor child who does qualify as the eligible designated beneficiary, you have the period of time until they reach majority plus an additional 10 years tacked on. What is the age of majority? Each state designates that. Louisiana's an year 18 years old state. Some states are 21 years old. The regulations also have another exception. If a child is still in school pursuing a degree and has not reached their 26th birthday, they are still considered for this purpose to be a minor there. There is a very strange rule here that is a very bad trap for the unwary lawyer, estate planning lawyer. For minor children, it is not uncommon when a client has multiple children, some of which may be majors, some of which may be minors. We often draft testamentary trusts or inter vivos trusts in a single trust instrument, creating a single trust with multiple children as beneficiaries. And we often say, okay, at my death, I direct the trustee to subdivide the trust, one for each beneficiary in a separate trust, even though we have one trust instrument. The code and regulations take the position that with children, that does not successfully make each trust a separate trust from inception, so that the child is the only beneficiary of that trust, so that it will then qualify for the child's period of time during their minority. So we have a dilemma here. The only way to use the full stretch out of the child's life expectancy is to have a conduit trust, but most of our clients do not want a child hitting the age of 18 to get that to get that much property. They want to have the trust last longer. So you're going to have an inherent problem there in satisfying those requirements. What about disability? The third exception. The definition of disability in the code and regs is the more restrictive one. In other words, you're only disabled if you can not participate in any gainful employment activity, and it's permanent. The fourth category is, let me back up. Once the disabled person who's now an eligible beneficiary dies, then again, the 10-year period tacks on at the end. The same thing is true for the chronically ill. The definition of chronic illness is an odd one. It's a bit amorphous. A chronically ill individual is one who's ill with an indefinite duration, reasonably expected to be lengthy in nature. The rule about non-severance of trust for children is different for disabled and chronically ill. You can have a single trust that breaks up into separate trusts for disabled or chronically ill for some reason. Again, that trap of the unwary for children is really vicious. Most lawyers are not going to know about this and will make a big mistake there. The final and fifth eligible designated beneficiary is odd. In other words, the beneficiary is not more than 10 years younger than your client. What is that about? It's usually there to take care of people who don't have any children and they want to make beneficiaries a younger sibling. In that case, you can use the life expectancy of the younger sibling. When that sibling dies, then you tack on another 10-year rule there. The reason why all of this is important is in the estate planning area, as time has marched on, I've been at this for 44 years now. Early on in my career, most people of wealth had wealth because they had a lot of real estate. And then as time marched on, you started to see in administering successions, wealth was in stocks and bonds. And now, a good bit of the wealth of our clients are in non-probate assets, i.e., in 401k plans and IRAs. And we as lawyers spend a great deal of time carefully drafting wills with testamentary trusts and taking care of all of the details there. But the fact of the matter is that carefully drafted will may not even apply to the majority of the client's assets that are tied up in non-probate assets such as IRAs and 401ks. So, and we incorrectly give short shrift to those beneficiary designations. Now we should spend at least as much time on the beneficiary designations of these plans as we do with the will. And sometimes we're pushed and pulled. We can't satisfy all of the clients' desires because they would love to stretch out the required minimum distributions as much as they can and to have the plan assets grow income tax free for as long as possible. But that may be counter to the client's needs for having trusts with accumulation powers and things of this nature. So it's very, very important for we as estate planning attorneys to keep these things in mind and to make everything dovetail.